if a person tells you they have a firearm and they also have a concealed weapons permit, does that also allow you to search the vehicle for more weapons because they may be considered armed and dangerous? Hey guys, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat. These questions and so forth, really they're designed to keep the conversation going, because if you've been to my training, whether my training or my fellow instructors, John Ween, Zach Miller, Mike Boone, Jonka Jacob, Jake Bigelow, Mike Smith, we got Chris McFarland. We have all these great instructors here. If you've been to their training, you know, that's not going to be enough, okay? We have the best search and seizure training, but there's no way that you're going to be one and done. We teach here, hire to retire. Like, you have to have search and seizure training throughout your whole career, and this is a great question. So what the officer is saying, it's an officer from Philly. He's like, all right, so, you know, and he's saying, hey, I stop a vehicle. The operator voluntarily tells me that they have a valid concealed carry permit and they're currently in possession of a firearm. Well, that's great. They don't, to my knowledge, you know, people in Pennsylvania do not have an obligation to legally even tell you that they're carrying concealed. So this is one of the good guys so far, right? Not only does he have a concealed weapons permit, he's also telling the officer, hey, just so you know, I got this permit. The question is, does that disclosure of the CCW also allow a frisk of the vehicle for additional weapons? And, you know, and the cop is saying, I know I can disarm this person, and can I now look for in the vehicle for additional weapons under any kind of case law? Well, let's look at the rules here, okay? Number one is, what gives you the authority to frisk a vehicle for weapons? That is Michigan versus Long, and that's a case from 1983, U.S. Supreme Court. And they said that in that case, this guy, Long, he was drunk. He crashed in a ditch. They told him to kind of stay still. He was outside the car by the time they arrived. He was kind of going for the door of the car, whether to leave or to grab a weapon. They thought that he was armed and dangerous. The way he was acting, they look in the door. They see a knife. They look for more weapons. They open up the center console, and they see drugs, right? So the question in that court was, in that case was that a lawful protective sweep of the motor vehicle? The U.S. Supreme Court said yes, because they had reasons to believe that he was armed and dangerous. He was intoxicated. He was not listening to commands. He was going for the car. You get my point. They already saw, and then they saw one weapon in plain view almost immediately. Then they could look for more weapons. Well, what about a person that is concealed carry? They're considered armed and dangerous? No, right? No, they're not. So now some states don't agree with this. California, Michigan, and Minnesota are three examples where their judges are absolutely the most anti-gun people, you know, and they're just like, hey, you know, guns equal danger. No, they do not, okay? Teach that to your wildlife officers, you know, who are contacting a hunter with their rifle slung in their back. You think those guys are disarming every single hunter? Of course not, right? Are you disarming every single off-duty cop? Why not? I mean, aren't they armed and dangerous too? So the answer is no. I don't buy that. And you know, maybe I'm jaded because I'm a huge Second Amendment advocate, but I'm going to teach you what I think that U.S. Supreme Court is going to say. Now, they're not going to say that, you know, simply having a gun is automatically dangerous. A really good, first of all, let's start with a Pennsylvania case. This is going to be the Commonwealth of Pennsylvania versus Michael J. Hicks. A case decided on May 31st, 2019. Essentially what happened here is a person calls up and says, hey, there's a guy concealing a firearm. And, you know, high crime area, you know, the caller was probably making a stereotype that this guy can't carry a gun. The cops stopped him. They, you know, he was not carrying lawfully. And then when they were asked, like, why did you stop this guy? Essentially, because we got this call for service that this guy's carrying a gun. And the Supreme Court of Pennsylvania overturn this, right? Because here's the deal. This is not going to work. We don't, just because you Pennsylvania is relatively a pro-gun state, considering that they're close to the East Coast, and that they have a shell issue permitting scheme. They've had it for a long time. All states are shell issue now. I understand that, but they've been this way for many, many years, despite bordering, you know, New Jersey and the like. And the point is like, they just don't have this mentality there that, hey, if I see you with a gun, even if you live in a high crime area, you know, you're carrying unlawfully. In fact, I think most people in high crime areas are good people. They're hardworking people. They don't want to be the victim of crimes, by their gangbanger neighbors, right? So they do get firearms lawfully and so forth. But the point is, this court made it very clear that seeing a gun does not mean it is automatically going to be unlawful. The other case that is persuasive authority, but it is not binding authority, is a case out of Indiana. This is Davis versus State, Indiana Court of Appeals, 2019. Davis versus the state of Indiana. What happened there is this guy said he got pulled over. He said, "Hey, by the way, I'm a lawful concealed carrier," and they see that they know he has a gun in the car. They try to recover his gun. He wasn't even on his person. The gun was on his person, but the gun was being carried lawfully per state law. They wanted to recover that gun. They found marijuana instead, marijuana and a firearm, and they charged him accordingly. And the Indiana Court of Appeals said, "Look, you got a problem here. The guy's not dangerous. Having a gun, legally carrying a firearm in this manner doesn't make the person dangerous." I got to tell you, right? You can kind of see that I'm pretty much into firearms. I got to tell you, every time I pulled over somebody, when I was a trooper, they were the last people I thought they were going to be a danger to me. In fact, I thought they were one of the good guys, right? Especially when they actually not only had the gun in the car lawfully, but they also had that concealed weapons permit, because that told me they went through a government background check. They submitted themselves to an investigation to some point, to a background check, training. My state required some training. And I'm like, you're one of the good guys. In fact, I thought to myself, if I ever got into a pickle and I was on the side of the road in the middle of nowhere fighting two people during a traffic stop, and this guy was, coming up on me, and he saw me on the ground getting my ass kicked, he'd probably be one of the guys that would get out and start helping me. So, personally, that had a little, it was a factor in my discretion about whether or not I took enforcement action, depending on what they were doing, right? So the point is that armed does not mean dangerous. If that's what the Supreme Court meant, then why did they even put the word dangerous in Terry versus Ohio? Why not just say, hey, you can do a pat down if the person is armed? Why did Michigan versus Long also say armed and dangerous? If all they meant was armed, why waste government ink and and also add the words and dangerous? Why don't you just say armed? But they didn't, did they? Because that's not what they meant. They meant armed and dangerous. Okay? I've been armed since I was 21, right? I'm a concealed carry advocate. I've not been dangerous ever because I don't have bad intent. So the point is, let's make good case law. Let's describe why we're going into a person's car for more than just the fact that they are complying with the law. I mean, maybe we're also violating their Second Amendment rights by tossing their car for nothing more than doing what they're allowed to do. All right? That's my opinion on it. And you're going to be like, but Anthony, you don't work the streets anymore. You're not out here. We have our sixth sense. Well, that's called a hunch. Let's have objective facts to believe that the person is a danger. All right? All right. If you like what we're doing here at Blue to Gold, can I ask you a favor? Hit the like button. That tells YouTube, hey, show this video to other like-minded people, other people that are, binging on donut operator type videos, right? And cop stuff. Leave a comment, bad or good. Hey, I agree with you, Anthony. I completely disagree with you. Hey, look, this is a free country. I want to hear your points of view too. I'm trying to learn. If you have a different point of view, I'm trying to learn. I'm not closed-minded. Share with your friends. Pass this around. And also, visit our webinars. We have weekly webinars, usually on Wednesday nights. They're totally free. Hundreds of your fellow officers are there, yucking it up. I'm asking and answering questions throughout the webinar. Okay? All right. Until next time, my friends, stay safe and make good case law.